Is your ex planning to move out of state, and you're concerned about how it will affect your divorce, custody arrangement, or visitation rights? In this video, we'll walk you through the steps you need to take if your ex wants to relocate, and how it may impact your legal rights, especially if you share children. We'll discuss how to protect your custody and visitation rights, what the law says about relocation, and the actions you can take to ensure your child's best interests are prioritized. Whether you're in the middle of a divorce or already have a custody arrangement in place, understanding your legal options is crucial to navigating this challenging situation. We'll break down the legal steps from negotiating with your ex to filing a petition in court so you can make informed decisions and protect your rights. Key topics covered. 1. Legal framework for relocation, what the law says about moving out of state. When one parent wants to move out of state, it can be a complex legal issue, especially if there are children involved. We'll explain the laws governing relocation in divorce cases and how these laws vary by state. We'll cover how relocation impacts custody orders and what you can do to address the situation. Relocation and custody orders. If there's a custody order in place, relocating without permission from the court could be considered a violation of that order. We'll discuss what needs to be done legally if your ex wants to move, and what steps they need to take to seek approval from the court. Best interests of the child. Courts primarily focus on the child's best interests when making decisions about relocation. We'll break down the factors courts consider when evaluating whether or not a parent can relocate, such as the reason for the move, the potential impact on the child, and the relationship between the child and the non-relocating parent. 2. What to do if your ex wants to move. Negotiating with your ex. Before heading to court, it's a good idea to try to resolve the issue through negotiation or mediation. We'll talk about the importance of trying to work out a solution that works for both parents and the children, including revising custody and visitation arrangements if necessary. Sending a notice of relocation. In many states, the parent who plans to move must provide written notice to the other parent. We'll explain what this notice should include, such as the date of the proposed move, the new address, and the reason for the relocation. You'll learn how to respond to this notice and the timeline for filing a petition in court if needed. Filing a petition to prevent relocation. If you disagree with your ex's move or feel that it will negatively impact your relationship with your child, you may need to file a petition with the court to block the relocation. We'll explain the legal process for doing this, including the forms you'll need to file and the time frame for requesting a hearing. Custody modification requests. If your ex's move is approved, you may need to request a modification to the existing custody arrangement to account for the new living situation. We'll discuss how to petition the court for a modification and what factors will be considered when making a decision about custody and visitation. The reason for the move. Courts will evaluate the reason behind the relocation. If your ex is moving for a job, a new relationship, or other reasons, the court will look at whether the move is in the child's best interests, or if it's an attempt to interfere with your custody and visitation rights. Impact on the child's relationship with both parents. One of the most significant factors in relocation cases is how the move will impact the child's relationship with the non-relocating parent. We'll discuss how courts weigh the emotional and practical impact of the move on your child, and what evidence may be needed to demonstrate that the relocation is not in the child's best interest. Ability to maintain a relationship. Post-move. If your ex does move, the court will consider how you can continue to maintain a meaningful relationship with your child. We'll explore options like adjusting the visitation schedule, using technology for virtual communication, or negotiating travel arrangements to make the situation work. Working with an attorney. Navigating the complexities of relocation cases can be challenging, so it's important to work with an experienced family law attorney. We'll explain how an attorney can help you understand your rights, gather evidence, and present your case to the court in the best light, documenting your concerns. If you believe the relocation will negatively affect your child or your relationship with them, documenting your concerns and the impact it could have is crucial. We'll offer tips on how to gather evidence such as communication records, school performance, or emotional impact to present a compelling case to the court. Alternative solutions. If preventing the move is not possible, we'll discuss alternative solutions such as adjusting visitation schedules, arranging for shared holidays, or proposing a relocation plan that allows both parents to stay involved in the child's life. When one parent wants to move out of state after a divorce, it can create significant challenges, particularly when it comes to custody and visitation. By understanding your legal rights and working through the proper legal channels, you can protect your relationship with your child and ensure that their best interests remain a priority. Remember, the key to addressing relocation issues is communication, documentation, and seeking the right legal support to help you navigate the process effectively.